One of the standard features of an initiative is the defense of that initiative. For example, does the initiative allow the proponents or a third party to defend the measure's validity if it is challenged in court? Now, generally, laws, including initiative measures, are defended by the Attorney General. However, there have been occasions when the Attorney General has chosen not to defend a measure in a court of law. As a result, some initiatives put forth a provision that's intended to grant legal standing to the proponents of the ballot measure in order to defend its validity in a court of law. The California Supreme Court has issued a decision regarding standing to defend a ballot measure's legal validity. In a post election challenge to a voter approved initiative measure, the official proponents of the initiative were authorized under California law to appear and assert the state's interest in the initiative's validity and to appeal a judgment that had invalidated the measure when public officials who ordinarily would defend the measure on appeal declined to do so. The case is from 2011. It's called Perry versus Brown. The citation is 52 Cal 4th 1116. And here the California Supreme Court ruled that it's essential to the integrity of the initiative process that's embodied in the Constitution in Article 2, Section 8, that there is someone to assert the state's interest in an initiative's validity on behalf of the people when the public officials who normally would assert that interest decline to do so. And the constitutional and statutory provisions relating to the California Attorney General's authority and responsibilities do not preclude others from asserting the state's interest in the validity of a challenged ballot measure. So the following might be an example of initiative language on defending the measure. Notwithstanding any other provision of law, if the state or any of its officials fail to defend the constitutionality of this initiative following its approval by the voters, any other state governmental agency of the state shall have the authority to intervene in any court action challenging the constitutionality of this initiative for the purpose of defending its constitutionality. Whether such action is in state or federal trial court, on appeal, or on discretionary review by the Supreme Court of California or the Supreme Court of the United States.